So a federal court is now deciding if the New York concealed carry law, which the state passed in direct defiance of the Supreme Court's Bruen decision, is unconstitutional and needs to be enjoined. So let's talk about this. But real quick before we jump into this video, if you agree that New York needs to stop violating the Second Amendment, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee is an amazing company and they're huge Second Amendment supporters. You can actually buy coffee that supports directly organizations like Gun Owners of America and Firearms Policy Coalition. So if you're interested, I will leave a link to them down in the details section. And if you use the code ARMSCHOLAR, you can get 10% off of your order. So like I said in the intro, the state of New York is being sued by Gun Owners of America because of the new concealed carry law, which they passed in direct defiance to the recent Supreme Court ruling in New York State Rifle and Pistol Association v. Bruen. The Bruen case was a challenge to the state of New York's concealed carry permit requirements. The state of New York required a person to provide proper cause to be issued a permit to carry concealed. The issue was that the state of New York did not consider self-defense a proper cause, and therefore on that justification alone, people had their permits denied. The state of New York had a may issue scheme like many other liberal states do as well, like the state of California. This may issue scheme had the subjective proper cause standard, which gave complete discretion to issuing agencies on whether someone was qualified to carry concealed. Well, in the recent Supreme Court decision in Bruen, the Supreme Court found that the New York proper cause standard and may issue schemes in general are a violation of the text and history of the Second Amendment. One of the primary findings of the Bruen decision was that the government bears the burden to prove that their restrictions are based in history and tradition of this nation. And therefore, the only question is what the public understanding of the right to keep and bear arms was during the ratification of the Second Amendment in 1791, and perhaps maybe even during the ratification of the 14th Amendment in 1868. But really, it's all based on the text and history of the Second Amendment. That is the only determination. In reaching this decision, the Supreme Court found that may issue licensing schemes are invalid, and instead pointed to shall issue jurisdictions. And those are jurisdictions where licenses are issued whenever applicants satisfy certain threshold requirements without granting licensing officials discretion to deny licenses on a perceived lack of need or suitability. But another thing that needs to be noted is that even in pointing to shall issue schemes, the Supreme Court recognized that there is inherent risk in all permitting schemes, including shall issue schemes. That is because there could be a state that has a shall issue scheme on its face, but still it's so hard for people to get their permits to carry concealed in a way that it still operates as a may issue. And another important thing that the Supreme Court said in their opinion that bears directly on this case is they said that the state of New York could not make simply everywhere a sensitive place. Sensitive places had to be limited in scope, and they would have to still comply with that history and tradition of the Second Amendment. So in this lawsuit, GOA argues that in spite of the Supreme Court's clear ruling in Bruen, the state of New York apparently did not get the memo or just decided to defy the Supreme Court outright. On the contrary, rather than representing a good faith attempt to bring New York law into compliance with the Supreme Court's Second Amendment ruling in that decision, the Concealed Carry Improvement Act, or the CCIA, instead doubles down on the New York law. So what is the CCIA which is being challenged in this GOA lawsuit? Well, first, the CCIA removes the now unconstitutional proper cause requirement in New York. However, in its place, this law creates a good moral character requirement. The law defines good moral character to now mean having the essential character, temperament, and judgment necessary to be entrusted with a weapon and to use it only in a manner that does not endanger oneself or others. This removal of the proper cause standard and replacing it with the good moral character standard is simply the state of New York moving from one subjective standard to another. The Supreme Court said you cannot leave the discretion to an issuing agency to decide when someone can exercise a right, but apparently New York just simply doesn't care. In addition to requiring an applicant to demonstrate good moral character, the CCIA imposes many more requirements on people seeking a New York carry permit, including requirements that the applicant shall meet in person with a licensing officer for an interview and shall, in addition to any other information or forms required by the license application, submit to the licensing officer the following information. And that information includes 1. Name and contact information of spouse, 2. 4 character references, 3. Certification of a training requirement, 4. Lists of former and current social media accounts from the past 3 years, and any other information the issuing agency believes is necessary. So not only are they shifting to a new subjective good moral character standard, but in doing so, they create a bunch of requirements and information you must give up, all of which can be easily used against you by the issuing agency to say that you are not qualified to have a permit to carry concealed. There are also other requirements that this new law incorporates, like requiring the applicants actually go through 16 hours of in-person training, including 2 hours of live fire training. So they also have some training requirements, some fees, and things of that nature. But beyond just changing training requirements and creating a more strict application process, this new law does something even more sinister. It pretty much makes the entire state of New York a sensitive place or gun-free zone. This law also expands these sensitive places so that almost everywhere in the state of New York is a sensitive place where even if you get a CCW permit, you still can't carry. The law adds 20 expressly identified locations where CCW is not permitted, but then it also adds in a catch-all provision, making any private property also off limits unless and until the private property owner expressly states through a sign that you can carry on the property. So despite what the Supreme Court said about making everywhere a sensitive place and how that type of law would clearly violate the Second Amendment in their ruling in Bruen, the state of New York still did try to do that very thing. They are trying to make the entire state of New York a sensitive place and pretty much limiting all public and private areas and buildings and businesses, making them off limit unless that actual business or area says that you can expressly carry at that location. Because of how this law directly violates the Second Amendment and that recent Supreme Court ruling in Bruen, GOA asked the district court judge in this case for a preliminary injunction against the enforcement of this law. A preliminary injunction is an injunction that you may be granted before a trial actually takes place. And the goal of a preliminary injunction is simply to preserve the status quo of the law and of the application of a law until a trial can actually be resolved. So GOA's goal with the preliminary injunction is to simply stop this law from going into effect until this case is actually resolved. Now, currently, the New York concealed carry law that's in question in this case is set to take effect on September 1st. Because of this, time is really of the essence. Last week on August 23rd, there was a hearing on the request for a preliminary injunction, and that took place before this court. So we will know soon what this judge decides he wants to do with the request for a preliminary injunction. That will come before September 1st is what he's indicated, which is actually this upcoming Thursday. There was also some reports from the public and some people who attended the hearing. There were statements that the judge was concerned about the ambiguity surrounding what actually counts as a social media account for the purposes of what law enforcement and agencies will be concerned about and look into. And it also seemed like the judge was concerned about how this social media provision actually impacts First Amendment implications as well. There was also indications that the judge was also concerned about how this law creates private businesses having to affirmatively give permission for someone to carry concealed within their business. He said that that kind of flips the status quo on its head by making it the burden on the business to say, yes, you can, versus the business typically having to say, no, carry is not permitted. So there seemed to be some concern by the judge on that aspect as well. So this is an important hearing that will determine whether or not the new concealed carry law goes into effect in New York. The judge indicated that he will rule before September 1st, before this law goes into effect, so we will know really soon. So if we get any more information, I will let you all know. If you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who turns on the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation is built by armed scholars, and this nation will be maintained by armed scholars.